share with you both the majority and minor. Interesting.
I welcome all the dignitaries on the dais, and I seek your permission to begin the final rounds. Thank you.
Yes, please. Yeah, please.
Cordial greetings to the bench. Recognizing the presence of the eminent members of the bench, the council seeks permission to refer to the bench as your lordships.
You prefer, Your Honor. I prefer it.
Yes, it's fine. Indeed, your honors. In the present, if your honors have had a brief perusal of the facts of the case, the council in the present instance seeks permission to proceed with their arguments.
Yes, please.
Much obliged, your honors. With the permission of your lordships, the council in the present case would argue for the first and the second issue for the petitioners. Your lordships, the first issue in the present instance being whether the court has jurisdiction to entertain the recognition and enforcement of awards application, and the second issue being whether the tribunal had the jurisdiction in passing the award. Your lordships, proceeding with the first issue, the council herein would submit three major arguments. That firstly, the New York Convention warrants the recognition and enforcement of the award. Secondly, your lordships, the court has jurisdiction over VDT. And thirdly, your lordships, Article 6 of the New York Convention in the present instance would not be applicable. Your lordships, arguing on the first contention that the New York Convention warrants the recognition of the award, your lordships, it is submitted that the Article 3 of the New York Convention reads that each state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of their own territory. Your lordships, herein reference must be made to the word shall. Your lordships, herein the word shall imposes a mandatory obligation on enforcement, the countries where enforcement is sought to enforce the award. Your lordships, furthermore, if your lordships would have the clarification number 1 in the present instance. Is the bench with the council?
Yes.
Much obliged, your honors. Your honors, the first clarification states that the Domestic Vikram's Arbitration and Enforcement Act grants the High Court of Vikram, which is the present forum, to recognize and enforce foreign arbitral awards under the New York Convention. Therefore, your lordships, coupled with the mandatory obligation under Article 3 of the New York Convention, and your lordships, the present forum through Vikram's Arbitration and Enforcement Act, having the requisite subject matter jurisdiction, your lordships, in the present instance, the award which is there must be recognized and enforced in favor of the petitioners. Your lordships, now arguing on the second contention, that the court has jurisdiction over the respondent Vikram Defense Technologies Corporations, your lordships, the council herein would make two-pronged arguments. Your lordships, firstly, the court has personal jurisdiction over VDT. Your lordships, the term personal jurisdiction refers to the type of jurisdiction that is rendered by the existence of continuous and systematic ties with the forum state that render a corporation to be essentially at home, your lordships. This principle was laid down in the case of Daimler AG versus Baumann. Your lordships, secondly, if your lordships would have page number 9 of the compendium.
Yes. Page 9 of your
Compendium, your lordships. Is the bench with the counsel? Much obliged, your lordships. In the present instance, your lordships, the case of Gudlup Tires Operations SA versus Brown very explicitly states that the paradigm forum for the exercise of general jurisdiction, which is personal jurisdiction, is individual's domicile. For a corporation, it is an equivalent place, fairly regarded as at home. Your lordships, identifying domicile, place of incorporation and principal place of business as paradigm basis for the exercise of general jurisdiction. Herein, your lordships, if a place is the principal place of business of a corporation, there might be there is jurisdiction of the forum in that present instance. Your lordships, if you would further refer to page number 14 and 15 of the compendium.
Yes.
Is the bench with the counsel?
Yes, please.
Much obliged, your honors. Your honors, in this judgment, Hertz Corp versus Friend, the phrase principal place of business was interpreted. Your lordships, at the bottom of page 15, there begins the sentence which states that we conclude that principal place of business is best read as referring to the place where a corporation's officers direct, control and coordinate the corporation's activities. It is the place that courts of appeal have called the corporation's nerve center, and in practice, it should normally be the place where the corporation maintains its headquarters, your lordships. If your lordships would now refer to clause 1.2 of the case record given under annexure A of the Moot proposition. 1.2.
What are you referring to?
The compendium, your lordship.
Page?
Your lordship, apologies, the Moot proposition, clause 1.2.
It's at page 3.
Your lordship, the annexure A which is given, which states Vikram Defence Technologies Corporation, the background of the parties. Annexure A, the agreement.
Yes.
No, we don't get you. Where you are referring to?
VDT, a fully owned government enterprise, that's one. Are you reading that clause?
Your lordships, 1.2 VDT, a statutory corporation established under the laws of Republic of Vikram. If your lordships are with the council. Your lordships, the Moot proposition in the present instance. Not the compendium, not the memorial, the Moot proposition.
Relevant facts it starts with?
Your lordships, it starts with a statutory corporation established under the laws of Vikram.
I don't think we have that.
We have the bench memo. We have the...
If your lordships,
What is the doc? What is that volume or whatever called?
the Moot proposition, your lordships.
Annexure A you are referring to?
Indeed, your lordship.
Starts with clause A, identification of parties.
Yes, your lordships.
This is the.
Yes, your lordships. At the end of this, annexure A is provided, clause 1.2 in that annexure.
Yes.
Yes, proceed.
Much obliged, your honors. Your Honors, the Council had established the interpretation of the term principal place of business being as the headquarters of a corporation. In the present instance, Your Lordships, the clause very specifically states that headquarters of VDT are located in Vikram. Therefore, Your Lordships, in the present instance, the court has personal jurisdiction over Vikram.
So when you say headquarters, is it the registered office?
Your Lordships, the paradigm for enforcing personal jurisdiction herein has been referred to the principal place of business. Principal place of business may or may not be an incorporated or a registered office. Principal place of business would be a place where the officers directly control, coordinate the activities. Your Lordships, herein seeing that the agreement that has been signed refers to the address in Vikram, Lordships, it can be very reasonably concluded that main operations have been taking place because, Your Lordships, the place of signing of such an important agreement does confer upon such offices importance, and Your Lordships, in the present instance, the corporate headquarters being the principal place of business, Your Lordships, by virtue of such existence, allow for personal jurisdiction.
No, signing is a matter of ease. Parties can sign anywhere. That does not mean that it will confer jurisdiction, right? But where is the registered office?
Your Lordships, as for the registered office, the Moot proposition is silent on the fact.
But it is certainly not the place that you are referring to.
Indeed, Your Lordships.
Then there is a problem, right? Then there is no jurisdiction.
Indeed, Your Lordships. However, in the present instance, the Council, while submitting their further arguments, would prove the jurisdiction.
Please.
Indeed, Your Lordships. Your Lordships, the second prong of the argument that the
Which
court...
is the country of incorporation.
Apologies, Your Lordship.
This Vikram Defence Technologies was incorporated in Vikram.
Indeed, Your Lordships, it is a statutory corporation of the Republic of Vikram. That means it was incorporated in Vikram. Now, Your Lordships, moving forward, the second prong of the argument that the court has jurisdiction over Vikram Defence Technologies Corporation is the fact that there exists quasi-in rem jurisdiction, Your Lordships. Quasi-in rem jurisdiction, Your Lordships, refers to the jurisdiction that arises from the existence of assets or properties. In the present instance, Your Lordships, even if the corporate headquarters might not be the principal place of business or incorporated place of business, but because there exist assets and properties, Your Lordships, in the present instance, the jurisdiction by existence of assets in the same case can be relied upon.
How are you saying that assets are here?
Your Lordships, a headquarter of a company is the property or the asset of a company. Your Lordships, because...
But apart from the office, is there any other asset which has been identified?
Your Lordships, the Moot proposition is silent on the fact. However, in the present instance, Your Lordships, if there is an office, and if there is an office of such importance that confers upon Vikram the authority or the right to sign agreements of such importance, Your Lordships, in the present instance, it cannot be reasonably assumed that they do not have assets over here. They might be having bank accounts, Your Lordships, they might be having certain assets in the present instance.
You are saying that they are a statutory corporation of Vikram. So it means registered office must be in Vikram.
Indeed, Your Lordships. If Your Lordships do agree on the fact that the registered...
No, but you are saying Moot proposition is silent. By implication, it must be registered office must be in Vikram, isn't it?
Indeed, Your Lordships. The councils completely agree. If the court is to assume that the registered office is in Vikram, Your Lordships, it would anyway strengthen the case of the petitioners by the clear implication being that the personal jurisdiction is present in the present matter. Your Lordships, arguing on the third matter, the third contention, that Article 6 in the present instance is inapplicable. Your Lordships, Article 6 of the New York Convention herein provides that if parallel enforcement and setting aside proceedings are going on, Your Lordships, the courts where enforcement is sought have a discretion to put a stay on the enforcement proceedings till the setting aside proceedings have not been resolved. In the present instance, Your Lordships, it has been observed that an enforcement proceeding cannot be stopped under Article 6 merely because of the fact that there are going on setting aside proceedings. Your Lordships, the initiation of setting aside proceedings does not put an automatic stay on enforcement proceedings.
No, but then there will be a conflict of judgment when there is a doctrine of comity. If there is a pending challenge to the award, then as this court we should await that.
Indeed, Your Lordships, the council recognizes your concerns. However, in the present instance, if Your Lordships were to refer to page 22 of the compendium, is the bench with the council?
Yes.
Much obliged, Your Honours. In the present MGM Productions case which has been presented in the compendium, Your Lordships, there is a line that states, a district court should not automatically stay enforcement proceedings on the ground that parallel proceedings are going on. Furthermore, Your Lordships, the next paragraph says that if the grounds raised in the setting aside proceedings are similar or same to the grounds that have been already considered by the arbitrary tribunal, Your Lordships, in that instance, Your Lordships, the courts would presume that the setting aside proceedings have been initiated to delay the enforcement of the award.
But that's their statutory right. I mean, even if the grounds are there, the court will have to take a call on that. They have exercised their right under the statute. So, I mean, for us to entertain this at this stage, specifically when there is a challenge, I mean, what heavens will fall if we, do not, we await right now.
Indeed, Your Lordship, the Council recognizes the concerns of the bench. However, in the present instance, Your Lordships, the petitioners are not denying that there exists a statutory right. Your Lordships, the petitioners can go for setting aside proceedings all they want, and the courts of competent jurisdiction will consider upon that matter. However, in the present instance, Your Lordships, if Your Lordships were to refer to the Europcar judgment given on page 24 of the compendium, just the next page, Your Lordships, several factors in that matter were highlighted, which should be used to determine whether Article 6 should be invoked or not. Your Lordships, the very first factor in that matter, it reads that general objectives of arbitration, the expeditious resolution of the dispute, such factors must be considered. Herein, Your Lordships, the New York Convention confers upon both the signatory states a pro-enforcement bias, Your Lordships.
No, but if we enforce, then the other, this thing will become infructuous, right? The challenge will become infructuous. So, challenge should be decided first and then the enforcement will follow.
Your Lordships, in the present instance, there is no statutory obligation for the setting aside proceedings to stop if the awards has been enforced. Your Lordships, the setting aside proceedings may very well continue after the enforcement. However, Your Lordships, the same goes for the enforcement proceedings. If setting aside proceedings can going on, Your Lordships, enforcement can take place at that very instance.
Tell us, what are the principles that govern the discretion of the court in deciding whether to defer to the appeal proceedings or not?
Apologies, Your Lordships, could you please expound on your question?
What are the principles that govern the exercise of discretion of the court to decide whether we should defer it pending appeal or not?
Indeed, Your Lordships. Your Lordships, if you would refer to page 24 of the compendium, the Council is highlighting the factors in the present instance. Your Lordship, the first factor is the general objectives of arbitration, which is expeditious resolution of the dispute. Secondly, Your Lordships, the status of foreign proceedings. Your Lordships, in the present instance, the foreign proceedings have just been initiated. The courts have only admitted the proceedings. They have not had any hearing. They have not adjudicated upon it yet. Your Lordships, there is very possible, there is a very high possibility that the same proceedings might take a lot of time. In that case, Your Lordships, the petitioners who are the award holders in the present instance to whom a right is accrued, Your Lordships, they would be put to hardship.
What happens if they succeed in the appeal and you're enforced and got your money?
Your Lordships, if they succeed in the appeal, that would be a very different scenario. Your Lordships, the scenario as of now is that there exists a right accrued to the petitioners through the arbitral award.
No, what I'm saying is, that is also a concern of us, our concern. Suppose we enforce the award now, and later they succeed, then what happens? What is the remedy of the appellant?
Indeed, Your Lordships, if the setting aside proceedings do succeed and the award is set aside, Your Lordships, the counsels for the petitioners would accept that award. Your Lordships, the counsel of the petitioners herein are submitting to the jurisdictions of the Honourable Court.
Acceptance means
You don't have
when
a
the money
choice, do
is
you?
when the money is gone.
Indeed, Your Lordship.
See, for not accepting or accepting, you don't have a choice. The seat of arbitration is Gondwana,
Indeed, Your Lordships.
and therefore the Gondwana law and the jurisdiction of Gondwana to sit in judgment over the validity of the award properly challenged in the courts of that jurisdiction is not in contest, cannot be in contest.
Indeed, Your Lordships.
Therefore, if the award is set aside, you are bound by that, subject
Indeed,
to
Your
the appellate
Lordships.
jurisdictions. But the question from the tribunal is that in the context of an active set-aside application pending before the court having jurisdiction, country and the court having jurisdiction, would it be a proper exercise of discretion to entertain and pursue the proceedings for enforcement of the award in Vikram? That's the short issue. How should the discretion be exercised.
Indeed, your lordships, the council recognizes your concerns, and for the same, your lordships, there are factors which are being delineated by the council. Your lordships, two factors have been delineated upon. Your lordships, the third factor would be if your lordships would refer to factor 4, sub-factor 2 in the Europcar judgment. Your lordships, it states that the characteristics of the foreign proceedings are to be seen, your lordships. If your lordships, the foreign proceedings are brought to set aside an award, your lordships, the court considering the enforcement would by a balance of scales render the award in favor of enforcement, and your lordships, not in favor of setting aside. Your lordships, this has been explicitly laid down in the Europcar judgment. Furthermore, your lordships, a balance of possible hardships is also to be considered. Your lordships, because of the setting aside proceedings, VDT, which is a corporation that comes from an economically susceptible country, your lordships, the country that faces economic hardships, the private corporations of which also faces hardships. Your lordships, they are forced to litigate the same matter in two different jurisdictions, and not just in the same country, your lordships, in two different countries. Herein, your lordships, the petitioners would be put at a very high pedestal of hardships in the present instance if your lordships, the award is not enforced. Your lordships,
So
furthermore,
that's the clause that you agreed voluntarily, and that is the construct of the clause. So hardship is not an argument, really.
indeed, your lordships, however, in the present instance, recognizing that VDT is a private corporation coming from an economically susceptible
VDT
country.
is not a private. it is-
Apologies, your lordships. Gontech is a private company coming from an economically susceptible background, your lordships. An award of $25 million, your lordships, in the present instance would very well help the private company Gontech in exercising their goals of being a exercising.
There are serious challenges on the jurisdiction point in the award,
Indeed, your
and
lordships.
it goes to the core of the award. So balance of convenience actually lie in waiting out, perhaps, because if the enforcement goes ahead, there are very serious challenges to the award. So
Indeed, your lordships, in the present instance, the submission of the argument, the petitioners has already been made. If your lordships permit, the council, seeing the paucity of time, would move to the next issue.
sure.
Much obliged, your lordships. Your lordships, arguing on the second contention that whether the tribunal had jurisdiction in passing the award, the council herein would submit three major arguments. That firstly, non-compliance with pre-arbitral mediation is not a jurisdictional bar. Secondly, the doctrine of waiver precludes VDT from challenging the jurisdiction of the tribunal. And thirdly, the tribunal rightfully assumed jurisdiction over the whole dispute. Your lordships, arguing on the first contention, that pre-arbitration mediation is not a jurisdictional bar, your lordships, the first prong of the argument is that the language of the clause does not reflect a mandatory nature. Your lordships, if you would refer to the case of Ravindra Kumar Verma versus BPTP Limited on page 34 of the compendium.
Please go ahead and read.
Yes.
Your lordships, the judgment states that therefore, if preconditions of mutual discussion is treated as mandatory, valuable rights of getting disputes decided by arbitration will get extinguished, and which is not a position which should be acceptable in law. Lordships, this is a settled position that pre-arbitral mediation is not a jurisdictional bar. Your lordships, the second prong of the argument being that an attempt to resolve the dispute through mediation in the present instance would have been an empty formality. Your lordships, the settled position in the present instance is that if the courts, after examining the correspondence and the conduct of the parties, come to the conclusion that there would have been an empty formality to undergo mediation, your lordships, such pre-arbitral mediation steps can be skipped.
Why it's an empty formality?
Indeed, your lordships, in the present instance, there were attempts initiated by the petitioners Gontech Private Limited to negotiate and then again to mediate. Your lordships, the respondents in both the instances have skipped the steps, they have not attended the meetings, they have not responded. Your lordships, because the conduct of the respondents in the present instance shows that they did not want to negotiate or mediate, your lordships, the same would be considered as an empty formality. Thirdly, your lordships,
No, maybe they were
What is the
waiting.
correct formulation? Is it an empty formality, or that the respondents by their conduct have eschewed?
apologies, your lordship.
What is the correct formulation of your argument? What should be the correct formulation of an argument? That the conduct of Vikram in abstaining from the mediation process would establish that they have eschewed the mediation process. Should that be the argument, or it's an empty formality?
Your Lordships, the councils herein are arguing that it was an empty formality. However, Your Lordships, in the future, if the respondents were to submit that the mediation was a jurisdictional bar, Your Lordships, the same cannot be done because they were the ones who initiated arbitration. Your Lordships, thirdly, pre-arbitration requirement is merely procedural in nature. Your Lordships, the issue relates to the admissibility of the claim and not the jurisdiction of the tribunal. Your Lordships, arguing on the second contention that the doctrine of waiver precludes VDT from challenging the jurisdiction of the tribunal, it is submitted that Your Lordships, VDT did not raise an objection in a timely manner. Your Lordships, Article 4 of the UN Citral Model Law and Article 4 of the Arbitration and Conciliation Act both provide that if an objection is there, the same must be raised at an earliest possible opportunity. If Your Lordships permit, the Council seeks 2 minutes to summarize and conclude their arguments.
Proceed.
Much obliged, Your Honours. Your Lordships, because there was no objections raised timely, Your Lordships, there is an implicit waiver on the part of the respondents. Secondly, Your Lordships, VDT's participation in the proceedings signifies a waiver. Your Lordships, in the case of Hindustan Wires Limited versus R. Suresh, it was very categorically laid down that it is that by clear conduct by the petitioner, I am not objecting to proceed with this matter before the learned arbitrator, by agreeing to file pleadings and obtaining convenient time for hearing of the matter, by agreeing to extend time to complete the proceeding, the petitioner has waived off their right to object. Your Lordships, thirdly, in the present instance, there is also waiver by election. Your Lordships, waiver by election refers to the doctrine wherein the respondents, or rather any party, makes such choices or rather elects to do something which signifies waiver, Your Lordships. The same case would apply in the present instance. Your Lordships, the fourth prong of the argument being this conduct of raising objections at an enforcement proceedings goes against good faith of the contract, Your Lordships. Your Lordships.
Where did this waiver of election come in place?
Apologies, Your Lordship.
Where did this waiver of election come in place? According to you, what is the point in which the waiver of election had come in place?
Your Lordship's, waiver of election refers to by choosing to do or not choosing to do something. Your Lordship, the election of the respondents in the present instance.
Of the two remedies, there should be an election.
Yes, Your Lordships, to object or to not object. Your Lordships, in the present instance, the waiver, the respondents have chosen to not object. Your Lordships, thereby there is an election of the choice of non-objection, which renders a waiver in favor of Your Lordships, the petitioner. Your Lordships, the third argument being that the tribunal rightfully asserted jurisdiction over the whole dispute. Your Lordships, it is submitted that Article 16 of the UN Citral Model Law, Section 16 of the Arbitration and Conciliation Act confers upon the arbitral tribunal the doctrine of competence, Your Lordships. The same gives the power to the jurisdiction to rule, the same gives the power to the arbitrator to rule on its jurisdiction, Your Lordships. Submitting a last argument. Your Lordships, non-compliance with pre-arbitral steps is an issue of admissibility and not jurisdiction. Your Lordships, therefore, in the present instance, the Council would conclude the submission on the first and the second issues. Your Lordships, it was an honour arguing before this bench.
Thank you.
Council would seek the permission to approach the dais.
Please.
Much obliged. Greetings to the honorable bench. The council will be dealing with the third issue, whether the award is hit under Article 5 of the New York Convention and is liable to be refused recognition and enforcement. The council will be thus arguing for the non-applicability of Article 5 on 3 grounds. Firstly, the parties have been precluded from challenging the composition of the arbitral tribunal under Article 5(1)(d). Secondly, the defense of non-arbitrability is inapplicable in the present case under Article 5(2)(a). And thirdly, the doctrine of public policy has to be narrowly interpreted under Article 5(2)(b). If it may please the bench, the council would like to begin with their submissions on these 3 grounds.
Please go ahead.
Much obliged, Your Honor. The preclusion of the parties from challenging the composition of the arbitral tribunal rests on 2 limbs. Firstly, the right to object the composition of the arbitral tribunal has been waived off in the present case. Your Honor, the principle of waiver states that if a party proceeds with the arbitration without raising any objection against any non-compliance within the time limit period, then the party has been deemed to have waived off their right to object. The council would place reliance on the principles enshrined under Article 4 of the UNCITRAL Model Law as well as Article 32 of the UNCITRAL Arbitration Rules, which lay down this principle. The council would like to draw the notice of the Honorable Bench towards the IBA guidelines on conflicts of interest in international arbitration, which can be found on page number 135 of the compendium. Is the bench with the council?
Yes, please proceed.
Whereunder General Standard 4A provides a time limit of 30 days from the disclosure of relevant facts to the parties to make any disclosure and to file any potential conflict of interest to this disclosure, failing which the parties will have to be deemed their right to object. Your Honor, the council would now request the Honorable Bench to kindly refer to para C.2 of the Moot proposition. Para C.2 of the Moot proposition, is the bench with the council?
Yeah, go ahead.
Para C.2 of the Moot proposition clearly lays down the factual matrix which prove that a complete disclosure had been made by Mr. Tara Kopiko, the sole arbitrator. She disclosed her previous employment status at Gontech, about her past employment status as in-house counsel till December 2019. Further, she even disclosed the fact that she is presently not consulting any matters to them and in the future also is not considering the same. Therefore, Your Honor, a complete disclosure had been made and it was within the complete relevant knowledge of VTT about the previous employment status. Despite this disclosure, VTT went on in agreeing to keeping ahead the name of Ms. Tara Kopiko as the sole arbitrator. Thus, any challenge that will be raised during the enforcement proceedings will be unfounded, because such opportunity had been provided to them at the time of the appointment of the arbitrator. Your Honor, secondly, under the principle of estoppel, a party cannot take advantage of a position to which it has previously taken when this change occurs to the detriment of the party. Thus, the parties are estopped from raising an objection against the composition of the arbitral tribunal when the right to object has been previously waived off by the parties. In the present case, at the time of the disclosure given by the sole arbitrator Tara Kopiko, there was ample opportunity for VTT to file any objections regarding a potential conflict of interest or regarding any potential arbitrator bias. However, they stuck with the position of keeping her name ahead as the sole arbitrator, and so therefore in the present instance they cannot raise any objections at the enforcement stage, as the principle of estoppel would not allow them to do the same.
Did they reserve any right to challenge the nomination later on?
Your Lordship, they only informally raised doubts. However, they failed to file a formal challenge, which is the basic requirement for filing any challenge towards the disclosure.
But they did raise a doubt.
Indeed, Your Lordship. However, the challenge to the composition of the arbitral tribunal has to be formally raised, and after the doubts were raised and a telephonic phone conversation occurred between Ms. Tara Kopiko and the director of VDT, Ms. Anji, and after the conversation, no further doubts was raised by VDT and Ms. Anji regarding the arbitrator bias.
No, so why were the arbitrator and parties talking? That's doubtful conduct for the arbitrator.
Your Lordship, in the present instance, the sole arbitrator was talking to the opposite party, VDT in the present case, to disclose her neutrality regarding the appointment as an arbitrator, and that she would maintain the principles of fairness and neutrality.
But the communication from the arbitrator, isn't they supposed to be marked to both the parties?
Your Lordship, it was marked to both the parties. However, specifically in this case, the doubts were raised by VDT, the director of Ms. Anji. Therefore, a complete disclosure was specifically made to her to clear any doubts regarding her biasness.
What is the nationality of the arbitrator?
Your Lordship, she is a Gondwanan citizen.
Then that becomes much more problematic, right?
Your Lordship, in the present instance, the nationality of the sole arbitrator is not a hindrance to her capability, as is not is a citizen of Gondwana, and that should not act as a hindrance to her employment status as an arbitrator. If the bench would refer to clarification 9 of the of the Moot clarification 9, it is mentioned that she is an experienced international arbitrator. So this again re-establishes the fact that she is competent enough to proceed as the sole arbitrator in the present case, and thus took the appointment in the present matter.
The objection to the arbitrator was presented in what form? Was it a written application, written objection, or how?
Your Lordship, in the present case, no such formal objection was given. In case of filing an objection against an arbitrator bias, it has to be a written form.
How was
it
it
in a
manifested?
The counsel would beg your pardon to expound on the question.
The objection to the arbitrator on the grounds of bias or possible bias was expressed how?
Was it in written form?
During the coffee break, or how?
Indeed, Your Lordship. In the present case, firstly, the name of Ms. Tara Kopiko orally disclosed over a telephonic call her neutrality status, to which no form of objection was filed by VDT, neither oral nor written in the present case. So therefore,
is at what stage this had happened, before commencement or during the proceedings?
indeed, Your Lordship,
And
this
was it part of any record? Is there any record that the arbitrator would say that they have reached out to me over phone and I have expressed this?
Indeed, Your Lordship, this disclosure and the doubts were raised before the signing of the arbitration agreement. So therefore, on signing of the arbitration agreement, both the parties were clear regarding their status of appointment of Ms. Tara Kopiko as the sole arbitrator. Therefore, this further establishes the contention of the counsel that if the parties were entering with complete knowledge and complete disclosure about the relevant facts, so therefore they are precluded from raising any challenge at this stage, the enforcement stage.
So there was no objection to the competence on the ground of bias or otherwise of the arbitrator, except in the present challenge in Vikram.
Indeed, Your Lordship, with regards to the biasness of the arbitrator, there was no specific challenge regarding it, neither before the appointment or...
What do you mean by specific? How else was it? By a frown? How was it expressed?
Your Lordship, in the present case,
See,
under...
Anything has to be expressed by the senses. Sight, smell, sound, touch, something like that, is it not? So how was the displeasure with Mrs. Kopike expressed? How?
Indeed, Your Lordship.
Whenever she sat and these people presented, they frowned at her. How do you infer that?
Indeed, Your Lordship. The counsel understands the concerns of the bench. The counsel would like to reiterate the fact that any objection regarding the jurisdiction of the arbitral tribunal, regarding the biasness of the arbitrator, it has to be made as a written objection in terms of a formal objection. However, in the present case, no formal objections were filed, only such specific oral doubts, certain doubts were there which were cleared after the disclosure, and further on, neither specific doubts nor disclosure nor objections orally or written were made by the respondents. If Your Honor have no further queries, the counsel would like to proceed to prove the inapplicability of the defense of non-arbitrability. Much obliged, Your Honor. The inapplicability of the defense of non-arbitrability rests on two prongs. Firstly, the defense of sovereign immunity cannot be used in the present case. The underlying principle, Your Honor, is that if a foreign state enters into a commercial contract with a party containing an arbitration agreement, then there is an implied waiver by the foreign state to preclude it from using its defense of sovereignty as an immunity against any enforcement actions to be taken against it. This can be referred on page 72 of the compendium in the case of KLA Constructions versus Embassy of Afghanistan.
Go on, please go on.
Okay.
Your Lordship, the counsel places reliance further on the case of international seaport dredging, where the rationale laid down was that irrespective of the nature of the parties, be it governmental or private, parties only enter into commercial transactions with complete awareness of the implications of compliance and non-compliance with the concerned contracts and any legal consequences that will follow. Therefore, it is clear, Your Honor, that both the parties entered with full conscience into the agreement regarding any possible implications that will occur out of this agreement and any legal actions that will follow. In this case, a dispute resolution clause had been incorporated into the agreement, to which both the parties had complete awareness about the implications.
I have a question. One, by entering into a commercial agreement, Does a state surrender its sovereignty? One. Second, what is the scope of sovereign immunity in a commercial proceeding? Yes.
Indeed, Your Lordship. Answering the first question, yes, a state on entering into a commercial contract with a private entity would lose its sovereign immunity. Secondly, Your Lordship, the extent of such sovereign immunity is such that if any matter is of grave importance and grave public policy concerning the government party, the sovereign party, then any such doubts or any such reservations regarding the national interest has to be precluded within the arbitration agreement or within the contractual clauses.
So does this come within that scope?
Indeed, Your Lordship, if in the contract any specific clause has been included which talks about the overriding effect of any public policy or national interest concerns over the entire contract or over any award or action taken against, then the case would hold true. However, in the present case, there was no such contract or there was no such clause within the contract which gave VDT the rights to override the entire agreement due to its sovereign immunity status or national interests. Secondly,
By the way, who is the sovereign here?
I beg your pardon, Your Lordships.
Who is the person claiming to be a sovereign? Vikram is not a party to the litigation, is it not?
Indeed, Your Lordship.
Vikram is the jurisdiction where the litigation is now presented. But the party entering into litigation is that VDT or something.
Statutory corporation.
It's a statutory
not
corporation.
A government.
Indeed, Your Lordship.
It is not a state by itself. It may be an instrumentality of state.
Indeed, Your Lordship.
Where does this argument of sovereign immunity arise from?
Indeed, Your Lordship. This is the this is exactly the submission of the council that in the present contract, VDT, the Vikram Defence Technology, was acting under as a statutory body. Therefore, any defence that it is acting on behalf of the state and claiming the defence of sovereign because it is directly controlled by the Ministry of Defence of Republic of Vikram would not fall because it is acting in the capacity of a private party. That is exactly the contention of the council. To further elaborate upon the same, the government-owned enterprises in contracts have to be treated as separate corporate bodies. Your Honor, the position of law is that the legal status and responsibilities of a state and the state-owned enterprises are distinct, and there is a clear line of distinction that has been drawn. In those federal corporations where the power to sue and to be sued exists in contracts in which the statutory body is entering, then that statutory body would be kept on the same pedestal as any respective private corporation. So, applying the facts to the present case, a similar correspondence can be drawn where VDT, which has the complete statutory rights to invoke the arbitration clause and enter into the arbitration proceedings, will have to be thus kept on a pedestal of a private body instead of claiming, giving them any defense of sovereign acting on behalf of the state. If your lordships have no further queries, the council would now proceed.
The Moot proposition does not define what is meant by a statutory corporation. Is it created by the statute or created under the statute? No idea.
Indeed, your lordship.
Is there a Vikram Defence Technologies Act of 1894 or something like that?
Indeed, your lordship.
No idea.
The council would urge the bench to refer to page 30 of the Moot proposition.
Go ahead, read.
Page 30, under page 30 it has been mentioned, the 1.2, clause 1.2, Vikram Defence Technologies Corporation, that a statutory corporation established under the laws of Vikram of Republic of Vikram in 2011 and has its headquarters at 654 Defence Avenue, Vikram. So this is from where Vikram draws its power as a statutory body. If your honor have no further questions, the council would proceed to prove the narrow interpretation of the public policy.
Yeah, go ahead.
Please.
Much obliged, your honor. A salient feature of an efficient arbitration proceeding, your honor, is that the scope of refusal and review is restricted and the award is only set aside in exceptional and rare cases. The New York Convention inherently reflects a pro-enforcement bias, and it states that a narrow reading of the public policy defense has to be applied to the factual situation of the case. And an award should only be set aside if it violates a state's most fundamental notions of morality and justice. Your lordships, the council would like to draw the notice of the honorable bench towards the case of Parsons and Whitmore, which is on page number 79 of the compendium. Parsons and Whitmore, a landmark US case.
Please go ahead.
In the present case, the equation of national policy with the state's public policy was dismissed on the ground that such an interpretation would become a parochial device protective of national political interests, which would undermine the convention's pro-enforcement bias. Therefore, Your Lordship, it is evident from the fact that in order to claim the defense of public policy, the threshold under the New York Convention is very high. And in the present case, such threshold has not been met. Merely claims of cybersecurity and national interest would not inshield VDT from the award. In order to further strengthen this argument, the Council would urge Your Honor to refer to para B.4 of the Moot proposition, which can be found on page number 22. Your Lordships, under para B.4 is the bench with the...
Go on.
On the issue of cyber privacy, neither Vikram nor Gondwana have enacted dedicated cyber security or data protection legislation. Your Lordships, it is thus clear that in the present case, there is no existing domestic law of cyber security or data protection legislation existing in the country of Vikram. Then how can the Republic of Vikram claim a defense of public policy on the grounds of violation of fundamental law of the country, if there is no such law or if there is no such detailed policy regarding the legal procedures of cyber security and data protection legislation?
But the court has said, the apex court seems to have held in favor of cyber security. That can also be a part of national policy.
Indeed, Your Lordship. However, no such precedent, has been relied upon by the respondents, which bolster their arguments that Supreme Court precedent is mentioned or appellate court precedent is there. In the present case, the statutory laws which are present, they do not have any such requirement. Your Lordships, the Council would further place reliance on the case of bulk trading essay versus Mahindra Sponge and Power, which is a judgment of the Chhattisgarh High Court, which has also narrowly interpreted the defense of public policy and which has stated the two grounds, that is, the public policy defense should only be invoked on the grounds of a violation of the most fundamental notions of justice and morality, and secondly, the fundamental law of the country.
Was this judgment in context of enforcement?
Indeed, Your Lordship, this is a 2024 judgment of the Chhattisgarh High Court, which has...
Age?
Your Lordship, the Council would beg their pardon as the present case has been not present in the compendium. However, elucidating upon the facts of the case, Your Lordship, in the present case...
Fundamental, I thought fundamental was an absolute expression.
Your Lordship, fundamental refers...
What is most fundamental beyond fundamental?
Your Lordships, fundamental in this instance refers to something which has been enrooted and enshrined within the statutory laws and within the constitution of a country from where it derives power, such that if a violation or if anything is contrary to the statutory law of the constitution, that will be a fundamental violation of it. Elucidating upon the facts of the case of the Chhattisgarh High Court, a contract of sale had been for coal had been entered into by the party.
The question was whether it's in the context of enforcement. Answer that.
Was it in context of enforcement, and did it arise out of international commercial arbitration?
Indeed, Your Lordship, this was a case which was arising out of enforcement of an foreign arbitral award, which was challenged on the ground that the foreign arbitral award would be violate the public policy. So their public policy of bulk trading essay, which is a government body. And in this case, therefore, the Chhattisgarh High Court, the single judge bench, interpreted that this defense of public policy has to be narrowly interpreted and it cannot have a wide ambit. To summarize the submissions of the Council, firstly, the parties have been precluded from challenging the composition of the arbitral tribunal. Secondly, the defense of non-arbitrability is inapplicable in the present case. And thirdly, the doctrine of public policy has to be narrowly interpreted. If Your Honor have no further queries, the Council would now proceed with the prayer.
Please. 1 minute, wind up.
Therefore, in light of the issues raised, cases referred, arguments advanced and authorities cited, it is prayed that the court may be pleased to declare that the court has jurisdiction in entertaining recognition and enforcement awards application and subsequently enforcing the award. Secondly, the arbitral tribunal had jurisdiction in passing the award. Thirdly, the award is not hit under Article 5 of the New York Convention and is not liable to be refused recognition and enforcement. And the court may pass any order which it may deem fit in the interest of justice, equity and good conscience. It was an honor arguing before the bench.
Thank you.
Thank you.
The council seeks the permission to approach the dais. The council seeks some time to arrange the papers. Greetings to the honorable bench. The council seeks the permission to address the benches, your honors.
Yes.
Your honors, I am the counsel for respondent in the case of Gontech Solutions Private Limited versus Vikram Defence Technologies Corporation. With due permission from the bench, the council would like to state the jurisdiction.
Yes, please.
It is submitted by the applicant that the court has jurisdiction in the present case. However, the counsel for the respondent contends the jurisdiction of this honorable court submitted by the applicant. The counsel for respondent will be establishing that the court lacks the jurisdiction in the present case in issue 1. The counsel seeks the permission to state the facts of the case.
Proceed.
Much obliged, your honors. If the honorable bench, this case concerns a contractual dispute between applicant Gontech Solutions Private Limited, a leading cyber security and AI firm, and Vikram Defence Technologies Corporation, the respondent, a state-owned defence corporation in Vikram. The dispute stems from a technology transfer and skill development agreement signed between respondent and applicant in January 2022. The agreement aimed to develop a quantum cyber security, a crucial project under Vikram's national security program. From the outset, the applicant failed to meet its contractual obligation. Given the repeated failures, the respondent had no choice but to engage quantum defense systems to salvage the project. The respondent then initiated arbitration on alleging contractual breaches by applicant. However, the tribunal wrongly assumed jurisdiction over the confidentiality breach, an issue that was never agreed upon for arbitration and had no legitimate basis in the dispute resolution framework of the contract. The tribunal issued an unjust award ordering Vikram Defence Technology Corporation, the respondent, to pay $13.75 million for alleged contractual breaches, $10 million for alleged contractual breaches of $10 million for a confidentiality breach that was never submitted for arbitration. Recognizing the flawed nature of the award, the respondent challenged it before the courts of Gondwana. Meanwhile, applicant initiated enforcement proceedings in the present honorable court, which clearly creates a risk of contradictory rulings. May it please the bench, for the convenience of understanding the issue at hand in chronological order, the counsel for respondent shall first deal with issue 2, which states whether the tribunal has jurisdiction in passing the arbitral award. My co-counsel will subsequently deal with issue 1 and 3 of the case.
Please go ahead.
The counsel seeks the permission to proceed with the arguments. The counsel for respondent submits before the honorable bench that the tribunal did not have jurisdiction to pass the arbitral award due to 4 primary reasons. Your Honor, the jurisdiction of an arbitral award is the bedrock of a valid and enforceable arbitral award. Firstly, the tribunal exceeded its mandate and acted alter petita. Your Honor, it is a fundamental principle that an arbitral tribunal cannot adjudicate matters beyond the scope agreed upon by the parties. In AGCO Corporation versus Angelin, if Your Honor may please refer to page 115 of compendium.
One.
115.
Please read.
The last paragraph on the left hand side. It says, arbitrators have the authority to decide only those issues actually submitted by the parties. Arbitration is simply a matter of contract between the parties. It is a way to resolve those disputes, but only those disputes that the party have agreed to submit to arbitration. Such agreement must not be so broadly construed as to encompass claims that were not intended to be arbitrated under the original contract. As with any contract, the touchstone for interpreting an arbitration clause must be the intention of the parties. we can clearly establish that courts may refuse to recognize or enforce the award where the arbitrator's decision go beyond the parties' pleadings or prayers for relief to render it ultra petitum.
I have a question. Was
Yes.
confidentiality clause a part of the agreement?
It was never contemplated by the parties.
No, I asked a different question. Was there a confidentiality clause in the agreement?
Certainly not. There was no confidentiality clause in the agreement.
Is that so? All right, please go ahead.
If your lordship please refer to page 26 of Moot proposition, para B, last third line.
20?
Page 26 of the Moot proposition.
Yes, please.
Para B, last third line. It states, does the honor have cite?
Yes.
It says that Gontech demanded full payment of the remaining 13.75 million under the contract and sought additional damages of $10 million for reputational harm caused by VDT's actions. Subsequently, on page 28 of the Moot proposition, where the arbitral award is given, does your honor have the cite?
Yes.
No, but clause 31 does talk about confidentiality, right?
Clause 31 does talk about the confidentiality, but confidentiality as a matter is a non-arbitrable matter.
No,
but
no. See,
arbitration-
you are stating wrong facts. The question I repeated was there a confidentiality clause? Whether confidentiality clause is there or not is an issue of fact. Whether it's arbitrable or not is an issue.
Apologies, Your Honor. Clause 31 was there. I interpreted the question wrongly.
All right,
Apologies
go
for
ahead.
that. Moving back to my argument, on page 28, the award is given. The award says that VDT was ordered to pay the remaining 13.75 million owed under the underlying contract. VDT was also directed to pay an additional $10 million in damages for the breach of the confidentiality clause. Thirdly, the tribunal dismissed Gontech's claim for reputational harm, finding insufficient evidence of actual damage. Your Honor, only the two claims were submitted in the counter claims by the Gontech. It was of the underlying 13.75 million under the underlying contract and $10 million for the reputational harm. But the tribunal went beyond its mandate and acted ultra petita by giving $10 million for the confidentiality breach, which was never pleaded by the parties.
So are you saying there was no specific prayer for damages due to breach of confidentiality?
Certainly, Your Lordship. There was no specific prayer. There were just two damages stated there were just two damages in the counter claims, and the tribunal went beyond those damages and gave damages on the confidentiality breach.
No, but the language of the arbitration clause is very wide, right? It says any dispute arising out under this agreement. So any dispute would mean dispute relating to confidentiality as well, right?
Certainly, Your Lordship, the matter of confidentiality is non-arbitrable as it involves the public policy and national security of the courts of Vikram. Your Honor, non-arbitrability precludes tribunal from adjudicating disputes that are intrinsically tied to public policy and state security. The test of non-arbitrability was clearly established in the case of ONGC Limited versus Saw Pipes Limited. Your Honor, please refer to page number 120, para 74 of the compendium. It explicitly states that. If I can read it out for
Yes.
you, Your Honor.
Just before that, before the tribunal, was there a specific challenge to non-entertainment or entertainment of confidentiality related prayer? Was there a specific challenge by you that the issue of confidentiality cannot be arbitrated?
No, Your Lordship. No, Your Honor. There was no such challenge.
No, so then how can you split the cause of action? Will the confidentiality related dispute, how will that be adjudicated? Are you saying that half of the dispute will be adjudicated in court and half of the dispute will be adjudicated in arbitration? Is that what you're implying?
Your Honor, the dispute which was pertaining to confidentiality, it was never contemplated by the parties.
No, the
So,
question is whether in your counter or whatever pleadings you filed, you objected to the arbitrability of the confidentiality clause or not. Not whether you filed another application or you are not sure. You understand the question? Shall I repeat it?
yes, Your Honor.
See, the question is whether in your counter you took an objection that this issue of confidentiality is not arbitrable, or whether you are taking that objection only here.
Yes, it's stated on page 26 of the Moot proposition.
Yes. Please read that B, claims and counterclaims, page 26.
It's jurisdictional challenge, heading A. It says
No, you read B on the claims and counterclaims, second paragraph.
VDT alleged that Gontech delivered incomplete and inaccurate technical documentation during phase 1 of the project, causing cascading delays in deployment. It claimed that Gontech's training sessions were insufficient, leaving key personnel unprepared to operate the QCS system. VDT also sought damages for the delayed substandard performance and national security risk amounting to $20 million.
So this is the VDT's claim.
These are the VDT's claims.
Yeah, next paragraph.
And subsequently, Gontech maintained that it had substantially fulfilled its contractual obligation. But only two damages were sought by the...
Yeah, just read that paragraph, second paragraph, last 2-3 lines.
Gontech demanded full payment of the remaining $13.75 million under the contract and sought additional damages of $10 million for the reputation harm caused by VDT's action.
So these were the claims.
These were the two claims, and this is what the council is trying to establish, that these were the only two claims submitted by the Gontech. While the tribunal in its order, it gave damages on confidentiality breach, rather it dismissed the damages on the reputation harm, and that is how it acted ultra petita to it. And because the tribunal acted ultra petita to it, the respondents were unable to present the case. The tribunal, by exceeding the scope of the submitted pleadings, it denied Article 18 to the parties, Article 18 of the Commercial Arbitration Act 1996, which is the law of the seat. It states that both the parties must be given...
Not the law of the seat. Seat is Gondwana.
Yes, the seat is Gondwana, and it's
Then the same arbitration act.
I did not, pardon me, Your Honor.
Seat of arbitration is Gondwana, is it?
Yes.
So when you say it violated the law of the seat, what do you mean?
The law of the seat, which is Commercial Arbitration Act, it states there is an article
Commercial Arbitration Act of
Gondwana.
Vikram.
of Gondwana, because that is where the arbitration took place, QCT Gondwana. So
it's the Gondwana Arbitration Act is in pari materia the Vikram Arbitration Act.
so basically the Gondwanas and Vikram's both domestic law are modeled closely on the UN Citral model law. So Gondwana follows the 1985 version of the model law, while Vikram follows the 2006 version of the model law. So Commercial Arbitration Act 1996 is the name of the domestic law of the Gondwana. So it states Article 18.
Proceed.
So under Article 18, under Article 18, it mandates both the parties should be entitled to fair hearing, and they should be entitled to present their cases in a fair way. So the respondent, they were unable to present their case. Moving on, the matter is non-arbitrable as it involves public policy and national security. Your Lordship, in the present case, the dispute is deeply interwoven with the National Cyber Security Initiative, which is the different Vikram 2030 initiative. This is evident from the Moot proposition and objective of the contract. Clause 2 of the contract, it is stated on page number 30 of the Moot proposition. Your Honor, I am reading that clause out. The clause 2 background, it states that in acknowledgement of the revolutionary nature of technology and the need for improvement of cyber security infrastructure at the Republic of Vikram, VDT intends to adopt this technology to enhance its national defense capability, and in furtherance of which the council would emphasize on this, that in furtherance of which GONTEC agreed to provide the requisite technology, expertise and training to achieve this objective. The council would emphasize the fact that the GONTEC already knew that the issue pertained to public policy. It involved this, during even the execution of the contract, the respondents were facing cyber attacks, cyber issues. So they knew that the matter concerns with the public interest and national security.
See, public interest and public policy are two very different concepts. Public policy is a ground on which an award could be challenged, but public interest as such is not a ground. If it's a commercial contract and if the terms are clear and there is no express clause in the agreement that if there is a problem with the implementation of the services, it will be a public issue, then you cannot perhaps rely on public interest to challenge the award.
Certainly, Your Honor. Public interest comes under the public policy. So, public policy is a whole circle, and under that comes public interest. So that is how we are connecting public interest and public policy. GONTEC and both the parties knew that the deployment of QCS technology was for the national security of Vikram. If Your Honor would come to page number.
So what is the implication? What are you saying?
So the confidentiality breach, the applicant has accused us that we breached their confidentiality. It was done to salvage our project. The project was divided into 3 phases. The first phase consisted of the blueprint, giving the blueprints, while second phase consisted of providing personal support and deployment of hardware and software of that system.
No, but before sharing, was it not possible to seek their consent?
The parties had a very strained relationship, and that is the reason that they did not go for the mediation.
If you had a strained relationship, can you breach the agreement?
Your Honor, VDT being a fully owned and state-controlled enterprises, it was the primary implementing agency for these initiatives.
No,
So,
they were
Which
communicating.
year law student are you?
second year.
Have you done matrimonial laws yet? Not yet.
We are still studying that, Your Honor.
Strained marital relationships are not a justification for infidelity.
I'll study on that, Your Honor. Coming back to the argument, that the matter was also non-arbitrable. The concept of erga omnes refers to the rights or obligations that are enforceable against the world at large. Rather than being limited to specific parties, in the context of intellectual property rights, this principle is particularly relevant because IPRs such as patents, copyrights and trade secrets are publicly registered and enforceable against third parties, making them inherently non-arbitrable due to the broader societal and legal implication. In our present case, the arbitral award in this case involved issues directly related to intellectual property rights, IPR, which are generally considered non-arbitrable in nature due to their public policy implication and the need for governmental oversight. This is evident from clause 31 of the contract, which explicitly states that GONTEC retains ownership of all intellectual property related to QECS technology. Additionally, clarification 11.
Catch your breath.
Yeah.
Survival is more important than your profession.
Thank you, Your Honor. Additionally, clarification point 11 confirms that the shared document includes encryption protocols, software architecture, integration manuals, and system performance metrics. Your Honor, I would seek just 1 minute.
Yes, you can have one.
But carry on. Please.
Please extend her time by 1 minute. Huh?
Yeah.
Yes, Your Honor, I'll proceed with the arguments.
Yes, please.
The clarification number 11 confirms that the shared documents included encryption protocols, software architecture, integration manuals, and system performance metrics, all of which are core components of Gontech's proprietary IPR. These elements are not merely contractual but fall under the purview of IPR, which typically requires registration and protection under national law. Disputes involving IPR are often reserved for national courts or specialized authorities as they involve public policy consideration and affect third-party rights. By ruling on matters involving IPR, the tribunal oversteps its mandate as such issues are beyond the scope of arbitrability. Therefore, the award is unenforceable as it improperly addresses the issue of improperly addresses IPR issue. Last,
I ask a question. You are saying IPR. Here it's a breach. No, copyrighted materials. Nobody's case that copyrighted material cannot be disclosed. Breach of confidentiality and breach of IPR are two separate issues. Breach of confidentiality is a violation of a contractual right. So how do you bring it under the net of IPR?
the breach of confidentiality, the confidentiality involved a technology. The shared technology was breached, was given to third party that involved IPR related rights.
Like what is it? Was it a patent?
Yes, that is.
Patent is disclosed. Patent specification is published, in fact. Anyway, go ahead. I think you. Right. Sorry.
Moving ahead, lastly, the arbitrator's blatant partiality and failure to uphold due process. Your Honor, it is a well-settled principle that an arbitrator must be free from bias, both actual and apparent. In Director General of Fair Trading versus Proprietary Association of Great Britain, Your Honor, in that case, it was held that any reasonable apprehension of bias renders the tribunal's decision void ab initio. Your Honor, if you refer to page 22 of the Moot proposition, para C2, the arbitrator had a prior professional association with the applicant, having served as its in-house counsel until 2019. The temporal proximity between her departure and the commencement of these proceedings raises a reasonable apprehension of bias. A fair-minded observer, upon considering these facts, would undoubtedly conclude that there existed a real possibility of partiality.
But there was no written objection from you, right?
Arbitrator was appointed unilaterally by Gondwan body. You had no say in the matter. You also put your left thumb impression on the arbitration agreement, didn't you?
Certainly, Your Lordship. We agreed for the arbitrator
If
to be
if the award goes in your favor,
I did not understand the question.
you agreed to the arbitration arbitrator,
Participate.
provided he or she rules in your favor, is it?
Certainly not, Your Honor. We mutually, both the parties mutually agreed to the arbitrator. But we agreed to a fair proceedings. We did not agree to an unfair proceedings. When the tribunal...
So therefore, you see, bias goes to the root of the jurisdiction. There is an error in the exercise of jurisdiction. There is a quorum non judice. If somebody is incompetent because of the inherent bias, then you could have objected. You agreed to it. Notwithstanding her past association with that Gondwana, the other party, her past employment with the other party, you agreed to that lady being the arbitrator. So therefore you waived any apprehensions you might have entertained in the antechamber of your mind with regard to her being biased. So you agreed to her as neutral at that time. Now when did you discover the bias after the award?
We agreed to her neutrality, and we agreed that we waived our
Answering your
apprehension. Can I see
Yeah,
some
answer the
moment?
question. Come.
Yeah, we agreed to her being neutral, and we waived our apprehension as well. But when the tribunal issued the award, when the award was issued by her, there came an issue which was not presented by the parties, and thereby we again had the issue of her being partial, because we did not agree to unfair proceedings, unfair trial by her. But the award was such bias, and it was tainted in nature, that it raises the issue of blatant partiality. If Your Honor is satisfied with my answer,
What are your
No,
grounds
I heard
for
your answer.
what are your grounds for bias?
the grounds we have raised for bias. Firstly, the IBA guidelines is also, the orange list in the IBA guidelines says that both the arbitrator and if the arbitrator had a past relationship with the party, there has to be a gap of 3 years. But in our present case, that gap was not
You
there.
waived that.
You knew it.
You knew it. It was disclosed.
We did waive that right, but we are also we are not precluded from waiving that right after the arbitration proceedings. We have certain case laws for that.
All right.
You impliedly accepted.
Not blindly open. After she disclosed that.
Actually, this could have been challenged if there was some new fact after she was appointed as an arbitrator, that she was perhaps, for example, still arbitrating for the previous employer on some other matter. That could have been a fact of, but once you have agreed, you cannot challenge the award on the basis of bias, and because the law is very clear, even incorrect finding of fact and incorrect finding of law is not a ground to challenge the award.
Your Honor, I certainly agree, but we agreed to her neutrality and her fair proceedings. But circumstances came that added to the fact that the arbitrator was biased.
You can challenge her award on permissible grounds that it's not wrong. But to say that she is biased after consenting to her on the basis of the knowledge of the fact, unless, as he says, some other facts came to your knowledge, is ordinarily not permissible. Anyway, you have answered the question.
All right.
If your Lordship is satisfied with the answer, my co-counsel will be dealing with
That's
issue
an
1 and 2.
improper question. The judgment will come later.
That's in a lighter
We are satisfied with the argument.
Thank you, Your Lordship.
Please.
Greetings to the Honorable Bench. The Council seeks permission to proceed with the pleadings.
Yes, please proceed.
Much obliged. Your Honor, today the Council will be dealing with specifically Issue 1 and Issue 3 of the particular case. Issue 1 deals with the jurisdiction of the court to entertain the recognition and enforcement of the award, and the third issue deals with whether the award falls under Article 5 of New York Convention and is liable to be refused recognition and enforcement. The Council upholds and reaffirms the arguments presented by my learned co-counsel. It is respectfully submitted that the jurisdiction of the Honorable High Court is contingent upon the jurisdiction of the Tribunal. Since the Tribunal lacked the authority to render the award in the first place, the Honorable High Court does not have the jurisdiction to entertain the application for enforcement.
Why do you say it doesn't have jurisdiction? The tribunal didn't have jurisdiction.
Because the question that the Council is dealing with is if the Honorable High Court have the jurisdiction to entertain the application of, and by necessary implication under Article 36
Please
clause
wait,
1.
Wait for a
Yes.
minute. Please adjust the time.
Which law school are you from?
Sorry.
Which law school are you from?
Two, states that if an application for setting aside or suspension of an award has been made to a court, then the court, where the recognition and enforcement is sought, may, if it considers proper, it may adjourn its proceedings. Continuing to the enforcement proceedings would lead to parallel proceedings, which would in turn lead to two different awards. If Your Honor may refer to the Moot proposition, page number 5, paragraph 23, page 5,
Now,
paragraph
one
23.
query there, assuming that Gondwana sets aside the award,
Yes,
the application for setting aside, is it not? And after that, then an application is filed for enforcement.
yes,
Because you are now contending that the award is void in Vikram,
yes.
is it not?
Yes, we are contending the same.
So they may similarly contend that the order of the court setting aside is also void, and then file for enforcement here after it is set aside in Gondwana.
But the council is
So
content.
therefore again there will be, either parallel proceedings or one proceeding overturning another. Now you are contending that Vikram has the jurisdiction to rule on the invalidity of the award.
I am contending that the High Court, the Honorable High Courts of Vikram, does have the jurisdiction. They do not have the jurisdiction for enforcement of the award.
Because the
as-
award is void.
No, because there are parallel proceedings which have been continuing in the courts of Gondwana for setting aside of the award, and because Article 36 Clause 2 gives the discretion to the court that if a parallel proceeding has already been continuing, the court may adjourn the proceedings and wait till the. Yes, that's the discretion of the court, and I will be making arguments to prove that how the award is tainted in nature and it has prospects of success. Therefore, the Honorable High Court should adjourn the proceedings as of now. May I continue?
Yeah, please.
But there's no stay as such on the award, right? Award is still enforceable, and it says the clause says that the award will be final and binding, right?
But I'm just contending in front of the court. I'm arguing that there should be a stay on the proceedings as of now because there are parallel proceedings which are going on.
But that is
Stay-
not for this court, no.
Yeah, the stay will
That
be.
you have to, the stay has to be sought there. in
No,
Gondwana.
no. May I reiterate the article once? So, Article 36, Clause 2 states that if an application for setting aside or suspension of an award has been made to a court, then the court where the recognition and enforcement is sought may, if it considers proper, adjourn its
Correct,
decision.
correct.
So
In that sense,
what are the
constructive.
parameters of propriety? What are the parameters of propriety? Does it make an astrological prediction of the outcome in the other court?
What are the grounds for deciding not to go ahead?
Yes. If Your Honor may refer to Memorial, page number 6, paragraph 26,
Go ahead, please go ahead.
it states that the courts adjourn the proceedings if there are chances that the setting aside proceedings have prospects of success, which is upheld by IPCO Limited versus Nigerian National Petroleum Corporation. So the prospects of success, that is the threshold for staying the proceedings here in the Honorable High Courts of Vikram. Also, another argument that I would like to make is, in Nor Solar SA versus Pablac Tie Carrot, the court held that the adjournment in enforcement can occur when the setting aside proceedings are ongoing, primarily to prevent wasted enforcement effort should the award be nullified. As per the factual matrix of the case, there are ongoing setting aside proceedings in the courts of Gondwana, which have chances of being nullified. Thus, to prevent the wasted effort, the court should adjourn the proceedings.
So is
No,
there-
the question was as to what are all the parameters. If you have
parameters are-
Unicitral, take Article 36. 36 1A, it sets out parameters. On what ground you are coming into it? The setting aside proceedings is in any of these plot. You have that article with you?
Yes, just give me a second.
Yes.
One parameter you stated was reasonable, prospect of success. Are there any other parameters?
So the parameters, the grounds for refusing recognition and enforcement. So through Article 36, we can, because if the award falls under Article 36, it will
36
have
1A, there is subclause 1.
36. Yes.
You fall under subclause 1. The arbitration agreement referred to Article 7 was under incapacity or the said agreement is not valid. That is not your case.
No, that is not our case.
Okay,
But
then
I'll be arguing under Article 36 subclause 1, subclause A, 2, 3 and
2, it says party against whom the award is invoked was not given proper notice of the appointment of an arbitrator or the arbitral proceedings or was otherwise unable to present his case. That
Yes.
was not your point also, because
No,
you
but-
participated, you had notice, you signed an agreement for appointment of arbitrator.
the council contends that Article 36(1)(a)(2), the parties should have been provided with an opportunity to present their cases, which falls under unable to present the case has the prospect of presentation of the case, opportunity to present the case. It is pertinent to note here that the respondent was deprived of the opportunity to present the case as the tribunal awarded $10 million to the applicant for an issue that was never submitted for arbitration by
So you
either.
are on that award amount, which was not part of the prayer,
Yeah.
not pleaded, therefore you never had any opportunity.
Yes, because we
Right.
never
Okay,
had.
proceed. Then 3, 4, in which category you fall?
Under 3, the award, the dispute not contemplated by and not falling within the terms of the submission. Shall I state the grounds first?
Yes.
Okay. And
So therefore, in clause 3, you
Cla-
say that the challenge is there,
yes.
therefore it should
yes,
not proceed.
Yes.
Okay.
And
Any
also,
other point in that?
And
Article
also
36?
under 36(1)(a)(b), first and second,
Yeah.
both. May I continue?
Yeah, read that for 1 and 2. How,
1
let
and
us
2.
see how.
The subject matter of dispute is not capable of settlement by arbitration under the law of the state. Second, the recognition of the award would be contrary to the public policy of the state.
Okay.
Shall I continue?
Yes, please.
It is humbly submitted that the courts of Gondwana have admitted challenge petitions indicating that Gondwana courts have found sufficient merits to proceed with the challenges. This case includes substantive allegations of arbitrators' impartiality, jurisdictional overreach by the tribunal, and decisions that appear to fall outside the scope of arbitration agreement, and the violation of public policy. The setting aside proceedings have prospects of success. These points shall be explained in detail in the next stage of the council's arguments. If the bench permits, the council seeks to address issue 1 and 3 together as both are closely linked. The approach will establish how the impugned order falls within the scope of Article 5 of New York Convention and Article 36 of Vikram's Arbitration and Enforcement Act, given that both the provision outlines similar grounds for refusing enforcement. Dealing with the issues together will provide a clearer and a more structured argument. May I deal with them together?
Yes, proceed.
Much obliged. The council will be dealing with the issue in a fourfold manner. First, the award is against the public policy of Vikram. Second, the award the issue was non-arbitrable in nature. Third, the award is beyond the scope of submission to arbitration. And fourth, Ms. Tara Kopiko was not impartial. The council submits that the award is against public policy of the country in which enforcement is sought, may be refused recognition and enforcement under Article 5(2)(b) and 36(1)(b)(2). In Parsons and Whitemore, the court held that the enforcement can be denied only if it violates the forum's fundamental notions of morality and justice, which was also held in United World versus Yakor, state that the public policy objections must be applied when an award undermines national interest or has special public interest in it. The award pertains to QCS, Quantum Cybersecurity System, a critical component for Vikram's Defend Vikram 2030 initiative, which aims to safeguard the nation against escalating cyber security threats and cyber attacks targeting critical infrastructure. Furthermore, allowing an award that disregards the moral and ethical imperative of safeguarding national security would be fundamentally unjust.
Whose
As it-
ethics? Whose ethics?
The ethics of the country of Vikram, the Republic of Vikram.
What does Gondwana owe you an ethical responsibility to safeguard your cyber security interests? It's a commercial contract, is it not?
It is the contract, but the contract pertains to national security of a whole
Okay,
nation.
national security, qua commercial agreement between the parties. What is the breach of national security that has occurred as a result of the conduct of Gondwana party?
So, as the award pertains to QCS, which is the critical component of Vikram's Defend Vikram 2030 initiative, which aims to safeguard the nation against the escalating cyber dispute. So, allowing the award that disregards the moral and the ethical imperative of safeguarding the national security would be fundamentally unjust, as it prioritizes private contractual dispute over the greater good of protecting millions of citizens from cyber threats, violating Vikram's core principle of morality and justice. If your lordship is satisfied, may I continue with the arguments?
Proceed.
The award is against public policy of Gondwana as well. So I will be arguing for the public policy of Gondwana, because a setting aside proceeding has already been started in the courts of Gondwana, and to show the prospects of success, they will follow their public policy. So I would like to make an argument for public policy of Gondwana as well, which falls under Article 34, Clause 2, Subclause B2, which pertains to the ground of being set aside, as the award violates the principles of natural justice, including impartiality and independence of the arbitrator, as held by Renu Sagar Power Corporation by the Indian courts, that the award is contrary to public policy if its enforcement would be contrary to the interests of the country. As QDS involvement was necessary for integrating the QCS into Vikram's national security framework, the award is against the interest of Vikram and thus has the possibility of being set aside.
But that jurisprudence has completely changed. That this is an old judgment perhaps, but the public policy is actually very narrowly defined. Interest, as I said, interest is very different from a ground of challenge.
Any commercial liability to pay damages will be against the interest of the country in that sense.
The council would like to contend that the contract pertains to national security. If your honor would refer to page number 30 of the Moot proposition.
Contract does pertain to, but there is a finding against you by the tribunal that you have chosen. And that finding is perhaps after analyzing all the evidence. And the law is very clear that unless you can make out a case of very strong interference, awards are not to be interfered at all. Right? Awards cannot be interfered at all. Right? So what is so egregious in the award? And today one of the question is, are you seeking simpliciter adjournment, or are you seeking the actual enforcement today itself?
The council is seeking adjournment of the proceedings.
So then, why are you harping on the merits of the matter?
Because as I referred earlier, the courts adjourn the proceedings if there are chances of setting aside proceedings to have prospects of success. Just to show that how there are prospects of the success of the award being set aside, so that the court may adjourn the proceedings. That is why I am going to the merits of the case, which is under Article 5.
Does the Gondwana court have an obligation to protect the national interests of Vikram?
Yes, if I may refer your honor to page number 21 of the Moot proposition. Here B.2, paragraph B.2.
Please read.
Here in the first line it's written that Gondwana legislature, I referred your honors to the wrong paragraph. Paragraph B.3.
B point
3.
3.
On page number 22. In the second line, Gondwana's courts have developed jurisprudence on these issues along lines similar to the legal precedents in India. So they follow, they take precedents from India
That's all right. Public policy considerations, etc. They also follow. Whose public policy? Is Gondwana's national interest or Vikram's national interest? Now, application to set aside is filed in the Gondwana court.
Yes.
You say that the award violates the public policy of India because India's security interests are threatened. That's one of your arguments, is
Yes.
it not? How does it violate the public policy of Gondwana?
Because as the courts of Gondwana uphold the security, the public interest of a nation.
Gondwana?
Of a nation.
Oh, Gondwana. Which nation?
You can possibly say international relations or friendly relations.
Committee is one thing. But you can't say that Mera Bharat Mahan should be national anthem of every country under the United Nations. Do you not?
Indeed, Your Lordship, but
मेरा श्रीलंका महान है, मेरा पाकिस्तान महान है, मेरा United States महान है. There are so many 126 mahans.
Your Lordship, the Council would like to contend that both Gondwana and Vikram are common law jurisdictions which have adopted
But separate nations.
separate
They
nations.
may have international tensions also, trade tensions, other tensions. So, setting
the
aside
sake of
application is in
international
Gondwana.
For the sake of international relations, the public interest and public policy of a nation also matters here. May I continue?
Yeah, please.
Yeah, can you just answer? Some substance of yours is that you would rely on Article 6,
Yes.
correct, New York Convention, saying that it has to be adjourned.
Yes.
It may be adjourned.
It may be adjourned. Now that article speaks about a competent authority, and there is a contention saying that you have not gone before the appellate tribunal. What is your call on it?
We did not go in front of the appellate tribunal as the award was fundamentally flawed. The appellate tribunal reviews the substance of the award. We do not want the substance of the award to be reviewed. We want to review the procedural wrongs which were done in the award, and therefore we went to the courts of Gondwana for setting aside of the proceeding. May I continue?
Yeah.
According to Parsons and Whitemore, non-arbitrability should concern a certain category of claims which is non-arbitrable because of special national interests vested in their resolution. In the present case, the issue of confidentiality particularly pertains to national interest and security because of strategic role of QCS in Defend Vikram 2030, and which is also integral to Vikram's national defense infrastructure and thus could not be resolved through arbitration.
But your country also recognizes the principle of competence, right?
Yes.
So then once the tribunal has ruled on jurisdiction, then where is the question of challenging it?
The tribunal cannot rule on a issue which is non-arbitrable in nature. Competence does not work on something which is non-arbitrable in nature, and we are contending that the issue was non-arbitrable in nature.
That is what the tribunal can rule, right? Whether the issue is arbitrable or not. And tribunal is the first and the only forum which can rule on the issue of arbitrability. Because the law is very clear that even under section 11 for appointment etc. for constitution, the courts are continuously saying that it's the tribunal which will rule.
The council also contends that as the tribunal was impartial in nature, so the
Not
award
partial.
becomes tainted.
Partial.
Was partial in nature, so the award becomes tainted, and which raises the issue of impartiality and
No, so then if the argument on partiality fails, you're saying that this argument will also fail, right? The issue of arbitrability.
No, because as the issue pertains to national security, may I refer Your Honor to page number 30 of the Moot proposition, clause 2 of the annexure, which is the main contract. It states that in acknowledgement of the revolutionary nature of technology and need for improvement of cyber security structure at Republic of Vikram, BDT intends to adopt this technology to enhance its national defense capabilities, in furtherance of which. So here, Gontech was fully aware that there pertains an issue of national security. The contract background states that. So the issue becomes non-arbitrable in nature as it pertains to national
Just
security.
hypothetically, now this BDT is a statutory corporation
Yes.
created under a statute of Vikram.
Yes.
An act of Vikram created this corporation. You thought the agreement is between BDT and that Gondwana. It's not between Vikram, the nation of Vikram, and Gondwana Technologies or whatever. So therefore, after you enter into the contract where you think that this QVT or whatever it is a great technology, other nuclear power countries will shiver before Vikram and all that. That's what your agreement would say. Then the Ministry of Defense comes up with a statement that this is the most stupid technology which is of no strategic relevance to Vikram's defense. Then what happens? So whatever statements that a statutory corporation makes or the assumptions would not bind the nation or vice versa, is it not? So your perception of what is in the national interest is different from the national interest.
I would like to point out to page number 20 of the Moot proposition.
Yes.
Under the heading of About the Republic of Vikram, here it is written in the second paragraph, the government's recent Defend Vikram 2030 initiative aims to develop a robust technological ecosystem emphasizing quantum computing, artificial intelligence and cyber resilience as strategic imperatives. The Vikram being vulnerable to cyber attacks under Ministry of Defence to pursue technological collaboration forms a part of Defend Vikram 2030. This shows that the contract between VDT and GONTEC was of critical national importance, which formed a part of it. And also, if we refer to the line above it, these cyber threats have underscored Vikram's vulnerabilities, which is digital infrastructure, promoting the Ministry of Defence to aggressively pursue technological collaborations with global leaders in the field of cybersecurity. So the contract was made in the need of cybersecurity. That is why it pertained to national interest.
Great.
All right.
May I continue?
Yes.
The Council humbly submits that Ms. Tara Kopiko was not impartial as she had prior professional relationship with GONTEC where she served as an in-house counsel. Her familiarity with GONTEC's operation and ongoing professional ties fundamentally compromise her impartiality and create bias. As Ms. Tara Kopiko also awarded $10 million for breach of confidentiality, which was never asked for, this affirms that Ms. Tara was impartial. The award thus falls under the scope of Article 51B, 51D and 52B of the New York Convention because of the impartiality of Ms. Tara Kopiko, and also raises similar provisions of Articles 36(1)(a)(2), 4 and 36(1)(b)(2). From the issue of non-arbitrability,
You mean partiality, not impartiality.
the partiality of Ms. Tara Kopiko.
You are saying she was impartial.
She
said
was
not
partial.
impartial.
Partial.
Not impartial.
Oh, not
She was
negative.
not impartial.
Sorry, I misheard you. Sorry. Yeah.
Non-arbitrability of the issue raises the ground of Article 52B of the New York Convention. The Council seeks 2 minutes just to summarize the issue. As stated earlier, that the courts adjourn the proceedings if there are chances that setting aside proceedings have prospects of success, as proved how the award is fundamentally flawed and has prospects of being set aside. The Honorable High Court of Vikram should adjourn the enforcement proceedings under Article 36, Clause 2 of Vikram Arbitration and Enforcement Act. Your Honor, with your due permission, the Council would like to recite the prayer. Much obliged. Whereof, in the lights of the issues raised, authorities cited, arguments advanced, and reasons given, the Council, on behalf of the Respondent, humbly prays before this Honorable Court that it may be pleased to declare and adjudge that the Honorable High Courts of Republic of Vikram should adjourn the enforcement proceedings. The Honorable High Court of Republic of Vikram does not have jurisdiction to entertain the recognition and enforcement of the award. The Tribunal did not have the jurisdiction in passing the arbitral award. The award falls under the scope of Article 5 of New York Convention and should not be recognized and enforced. The court being satisfied may also make any such order as it may deem fit in the light of justice, equity and good conscience, all of which is most humbly prayed.
Thank you.
Thank you.
Your Honor, the Council seeks permission to approach the case.
Just a second.
Much obliged, Your Honors. Your Honors, in the present instance, herein the counsel for the petitioners would make the rebuttals on the submissions as provided by the respondents. Your Lordships, very firstly pointing out that the respondents stated that the third party QDS was included because of defaults of Vikram. However, the Moot proposition lays down that QDS was involved because of their expertise in matters of cybersecurity. Herein, Your Lordships, the position stated by the respondent is very different as has been laid down in the Moot proposition. Your Lordships, again, Your Honours, respondents wrongfully stated that there is no confidentiality clause in the agreement.
Thereafter she corrected.
Indeed, Your Lordships. Your Lordships, the Honourable Bench had to point that out. Your Lordships, thirdly, the respondent stated that there was no challenge to confidentiality. Your Lordships, furthermore, merely having strained relations or VDT being the implementing agency of Ministry of Defence, Your Lordships, does not allow any breach of confidentiality or breach of any contractual obligation for that matter. Furthermore, Your Lordships, IPR out of contractual obligation is arbitrable, while IPR, core IPR issue might not be arbitrable. However, in the present instance, the issue is of breach of confidentiality through IPR, as it is on right in rem issue arising out of a right in personam, the same is arbitrable. Your Lordships, Eros International versus Telemax, the Bombay High Court ruled that infringement of copyright arising out of a term in agreement is arbitrable in the present in this instance, Your Honours. Your Honours, the respondents have repeatedly stated that they have waived their right to challenge the bias of the arbitrator, however, made subsequent submissions to that extent. Your Lordships, moreover, the respondents have relied upon the Renu Sagar judgment, but as pointed out by Your Honours in the present instance, the same is bad law and not binding upon the present bench.
Just one question. Although they phrased it that the confidentiality issue is not arbitrable, what they perhaps seem to mean from their arguments, as I understand it, that you never made breach of confidentiality as an issue to claim damages in your brief, in your claim, and therefore the arbitrator decided to award for breach which you did not seek. Isn't that correct?
Indeed, Your Lordship, the Council recognizes your concerns. However, in the present instance, if Your Lordships would refer to C point arguments on merits on page number 27.
27 of Moot proposition.
Moot proposition, Your Lordship.
Go ahead.
Your Lordships, the third paragraph, Your Lordships, third from bottom and third from the top as well. Your Lordships, it very well states that Gontech asserted that this breach caused significant harm to its competitive position in the industry as the disclosed information, which is herein the confidential information, Your Lordships, was highly sensitive and formed the backbone of its technological advantage. Your Lordships, herein there are arguments that have been made before the tribunal on confidentiality. Your Lordships, stating that the tribunal out of its own ruled on confidentiality is completely an untenable argument in the present instance.
No, but when there is no prayer,
Is there a claim?
there's
On
no
that
claim.
basis?
Yes, there's no claim at all. I mean, that really ties in with the prejudice argument, and it's a hefty amount which is being given to you without a prayer. Do you have any authority which says that if the pleadings are enough minus the prayer, that amount can be granted? Because there are many authorities to the contrary, that minus the prayer, it is really going beyond the scope of the agreement.
Indeed, Your Lordships.
The allegations are normally construed as exchange of pleasantries or unpleasantries. You have to quantify it in terms of money, is it not?
Your Lordships,
The whole dispute is about money.
apologies, Your Lordships. Your Lordships, in the present instance, if Your Lordships would again refer to the claims and counterclaims on page number 26.
Let him finish. He's answering the query.
Page number 26, Your Lordships, the second paragraph. Gontech maintained that it had substantially fulfilled its contractual obligations. The delays in phase 1, it argued, were arbitrable. Repeated requests for revisions and failures to provide timely feedback. Gontech accused VDT of breaching the confidentiality clause, Your Lordships. The same.
What
No doubt,
prohibited you?
no doubt.
Indeed,
These
Your
are
Lordships. Indeed.
You are a bad
Demanded full
person.
payment of the
My
remaining.
allegation is that you are a bad person. But I say, all right, if I suit against you saying you are a bad person, you did not do this, you owe me 10,000 bucks, you did not repay me 10,000.
And
But for
damages
bad
for
person, there is no
reputational
damages claim.
damages
The
for
absence of a
reputational
claim,
harm.
specific claim for breach of the confidentiality clause. Where does that 10,000 come from?
Your Lordships,
The tribunal.
the 10,000 comes from the reputational damage that reputational and competitive damage that occurred from breach of such confidentiality. Furthermore, Your Lordships, in the present instance, the petitioners are here for the enforcement of the award.
Confidentiality breach led to reputational damage, is it?
Your Lordships, the confidentiality breach led to two types of damages. Your Lordships, competitive damages, and Your Lordships, for the IPR and confidentiality in itself. Your Lordships, herein the competitive damages, Your Lordships, when an information that is so important to the company Gontech Private Solutions Limited was released to a third party without their consent, Your Lordships, there would be a reputational damage along with the competitive harm. Your Lordships,
do you agree the fact that the damages for breach of confidentiality clause has been awarded without a prayer?
Your Lordships, the councils would not agree to it in the present instance. Your Lordships, there have been counterclaims and claims. Your Lordships, the same is mentioned in the counterclaims. The same has been argued upon in the tribunals. Your Lordships, for the respondents to come here and argue that the same was firstly not present in the claim and counterclaim, and secondly, there were no argumentations. Your Lordships, both the statements are completely untenable, which have been made before this honorable bench.
Okay. Thank you.
Thank you.
It was an honor arguing before this bench, Your Lordships.
What now?
No, next she wants, yes, please. Please come.
Coming to the question, coming to the first question that my learned counsel posed, that the QDS was integrated, that we argued that QDS was integrated because it was not very important, but the council would like to point out to page number 24 of the Moot proposition, paragraph C.11, where VDT stated that involvement of QDS was necessary to integrate QCS into the broader national security framework. And the second question that my learned counsel posed, that no confidential, that my co-counsel said that there was no confidentiality clause in the agreement. That was an error, and my co-counsel corrected it. Just a second, Your Honors. On page number 26 of the Moot proposition, the fifth line, it is written here that VDT contested this assumption, arguing that the tribunal lacked the authority to adjudicate certain aspects of the matter. So we did contest the jurisdiction earlier also. Coming to the fourth question, that
What aspects?
The aspect of the breach of confidentiality, the line above it states that when the tribunal assumed jurisdiction over the disputes of breach of confidentiality, VDT contested this assumption, arguing that the tribunal lacked the authority to adjudicate certain aspects of the matter. Coming to the fourth question that the learned counsel posed, that we waived off the right to challenge the arbitrator's appointment. If Your Honor would come to page number 8 of the written submissions, paragraph 3.
Read, please. Read.
The line 3 here, it is stated that in O'Kine versus Roseburg, a party who had the opportunity to challenge an arbitrator during the pendency of the arbitral proceedings but failed to do so is not precluded from later contesting the validity of the arbitral award on the grounds of reasonable apprehensions of bias. The last question that was posed by my learned counsel was that Renu Sagar is now bad in law. If Your Honors would come to citation 19 of the written submission, there is another case that is stated by us, which is ONGC versus GECO. Here the court refined the definition of public policy, emphasizing its dynamic nature, encompassing involving public good and interest, and further incorporating patent illegality as a ground for refusal and expanding the previously established criteria. That was it. Thank you so much.
Thank you.
Which year are you? All second years. Well, this is exclusively for second year law students. You have done your commercial law course already? You are introduced straight into some international arbitration. We have a saying in the place I come from, that is on the day that the first food is given to the baby, he is given pickled rice. Very spicy food. instead of milk rice or something like that. Reading Perry Mason. Perry Mason, Earl Stanley Gardner was a fictional author who wrote fictional novels about a lawyer, fictional lawyer called Perry Mason. So that guy had a very pretty secretary called Della Street. He had an investigator called Paul Drake. He had a junior called Paul Jackson. So one day Perry Mason, after arguing a